let's talk about a couple of other things. Sorry, I'm going to go kind of quickly here. What rights are affected by marriage cases in Prop 8? The short answer is very little is changed by marriage cases and very little is changed by Prop 8. This is, obviously there's a lot of rhetoric on both sides, but as I mentioned, California has the best domestic partnership laws in the country, and in addition, the feds already didn't recognize the marriage because of DOMA, the Defense of Marriage Act. So as a result, prior to marriage cases, what you have is domestic partnerships with the full right of marriage, and no federal rights because federal rights didn't do it under DOMA. After marriage cases, you had marriage with the full rights of marriage, and again, no federal rights due to DOMA. After Prop 8, once again, we're back to there's essentially no legal change in the status of couple rights in California. I realize there's a strong emotional, rhetorical amount of energy put in here, but there's very little. There's a tiny footnote in marriage case which talks. There are 9 very, very tiny differences between the two, but they're essentially issues. So as a result, statements to the contrary on both sides, statements from church leaders, which you may have heard, statements from others saying that if Prop 8 is not passed, the sky will fall. Those are, as a matter of law, Prop 8 really didn't do much. And on the flip side, people who have said, Prop 8 is at the end to be qualified. It's not. I mean, it's an unfortunate case for advocates of gay rights, but it is, at the end of the day, it's changed very little in the legal playing field. One interesting thing that may have a legal effect in the future is President Obama has talked about repealing DOMA. If DOMA gets repealed, then Proposition 8 matters as a legal matter. Until then, it effectively, this is a lot of heat and noise, but not a lot of actual legal effect. And again, I realize that it is an important emotional effect for people that I've been friends with, but there's not a lot of legal change going on here. And just very briefly to hit a couple of other things, is the church allowed to get involved the way it was? The church is a tax-exempt organization under 501c3. What that means is that it cannot lobby for particular politicians, which it didn't here. It can't say vote for Laura Compton. And what it also can't do is it can't donate a substantial amount of its resources to lobbying. That is a totally fuzzy test. There's not a lot of law on that. The law on that suggests that if you're under certain thresholds, like 5 or 10%, then you're not giving a substantial amount. The church itself didn't actually give very much to Proposition 8. On the other hand, they used member lists and encouraged members to. I'm not actually a tax attorney myself, but a couple of friends of mine who do tax, one tax professor at Florida State I've talked to, has a paper on it and says that the church is pretty well within its legal rights. There's some questions about whether this should be changed. I mean, clearly the law did not anticipate a sort of private mobilization. If the church itself had given $30 million, maybe that would be a substantial contribution. Just telling members to doesn't look like on the organizational level, at least according to tax people I've talked to. And if that is something which the IRS chooses to change, it's very unlikely that they would apply that retroactively. So it's very likely that the church's actions are fine according to tax law. Again, I'm not a tax attorney, but this is what I have been told in discussions with tax people. And so, those are some of the legal issues, and if you have questions about more, we'll do Q&A.